Okay, students, I hope everybody's doing good. Hope you've had a good week so far, and this will be our lecture number 3. We're going to be talking about some constitutional law today. So we'll look at our notes, look at our handouts here, and look at number 19. We'll start with number 19. Full faith and credit constitutional clause mandates the enforcement of a judgment made in other states. Full faith and credit. Okay. What that says is, let's suppose we're in Alabama and you get a divorce in the state of Alabama, and your husband or your wife goes to California. Because let's say they're from California. So you both lived here in Alabama. Alabama had jurisdiction of divorce, and you won your case here in Alabama, but the other party, husband, wife, whatever, they go to California. All right, and file for divorce in California because that's where they're originally from, and their daddy knows the judge out there, and so let's go to California to do this thing again. Can you do that? And the answer is no, you cannot, and the reason you cannot because of the full faith and credit clause. Every state has to give full faith and credit to the law, to a judgment and the laws of the other state. In other words, if you get a judgment, let's suppose you sue somebody in Alabama. Suppose you talk about the long arm statute. Remember that? So you get somebody in here, you sue them in the state of Alabama, you have a trial, you get a $10 million verdict. They don't like that. They go back to Arkansas and say, let's try it again. We're from Arkansas. You can't do it. The Alabama court had jurisdiction. Same thing if you got the divorce in California and you come back to Alabama and we'll do it over, but you can't do it. Each state will give full faith and credit. And what you would do in those cases when they file, if the other party went to California to file for the divorce in California, you get a certified copy of your judgment, get a lawyer out there, file that with the court with a motion to dismiss, and the judge would grant it. And it would be, and that's because of the full faith and credit clause of the United States Constitution. Each state has to give full faith and credit to judgments and laws of the other state. Okay? All right, let's see where we go next. I'm turning to my page here. Y'all got it on your computer there. Number 21. Privileges and Immunities Clause requires that each state treat all its citizens of other states as they would their own citizens. All right? Now, we live real close, we're in Huntsville, Alabama, so we live real close to the state of Tennessee, don't we? Suppose the state of Tennessee says, okay, everybody in the state of Alabama, if you come up across that state line, you got to pay $50 to enter the state of Tennessee. Or either you got to show a passport. You got to show a passport to be able to go into the state of Tennessee. Can they do that? No, they can't because it's a Privilege and Immunities Clause. Okay, each state has to treat citizens from other states as they would their own citizens. So you could not have some kind of rule or some kind of law that makes the people from the state of Tennessee, if they enter the state of Alabama, you got to pay this kind of tax, or you got to do this, you got to do that. To come into our great state. No, you can't do that because that's called Privilege and Immunities Clause. You got to treat people from the other states just like you would their own state. Okay, so that's because of the Privilege and Immunities Clause. So you don't have to get another driver's license. If you go to Tennessee, can't say, well, if you're going to drive in the state of Tennessee, you've got to have a Tennessee driver's license. You got to come up here and I mean, I know you got an Alabama driver. I know you live in Alabama. You got an Alabama driver's license. You don't live in Tennessee, you live in Huntsville, Alabama. But if you're going to drive in Tennessee, you've got to have a Tennessee driver's license. No, that's not, they cannot require that. And if you live in Tennessee, that's a different story. But if you don't live in Tennessee, Alabama driver's license is going to be good enough to drive in the state of Tennessee. Okay? All right, let's go here now to the number 29. Number 29. The basis for the majority of federal laws regulating business activities is the Commerce Clause. That's probably one of the most important clauses in the Constitution in the business world, is the Commerce Clause. It says that the Commerce Clause is the United States government controls commerce between the states and the Indian tribes. That's what the Commerce Clause says. It's a very short clause, but it's a very important clause. It was the basis for finding the Civil Rights Act constitutional. And there was a case in Birmingham that was the basis for that. We're talking about stare decisis and precedent. The case in Birmingham was Ollie's Barbecue. Was the barbecue place. Used to, if you're driving down I-65 and going through Birmingham, it's not there anymore, but the big old sign right off the interstate, Ollie's Barbecue, is one of the most famous barbecue places in Birmingham. It's not there anymore, but back in the day it was, and you had the place, the Civil Rights Act, and the people at Ollie's Barbecue said, we still going to refuse to serve people we don't want to serve. If we don't want to serve an African American, we're not going to serve them. And I don't care what your Civil Rights Act says, because we're in the state of Alabama, and we're not involved in anything with the federal government. We don't let the federal government tell us what to do. So the federal government came in, filed a lawsuit, and so the case ended up going to the United States Supreme Court. But the Civil Rights Act was found constitutional because of the Commerce Clause. Ollie's Barbecue said, we don't want to serve who we don't want to serve. And so they go into court and they ask the people, the owner of Ollie's Barbecue, he said, we get our pigs for our pork raised in Alabama. We get everything we get. Everything we serve in Ollie's Barbecue comes from the state of Alabama. Nothing else. That's where we get it. Everything we do in Ollie's Barbecue, all the food, everything we do comes from the state of Alabama. All right. Well, they asked the guy the question is, do the people anybody come into your barbecue place, use that interstate highway out there? They get off that interstate highway, ever use the interstate highway, come to Ollie's Barbecue? Well, yes, sir, they do. Well, the wrappers, we've done a little research here, and the wrappers that you use to wrap up your barbecue sandwiches, they come in from out of state. They don't come from Alabama, they come from out of state. Do you have a telephone there in your barbecue place? Yes, sir, I do. Okay. We also did some checking, and the feed that you use to feed your pigs comes in from out of state. So would you say that's interstate commerce? Well, yeah, it would be. There you go. So you could, anything that you do, you're involved in commerce, and so therefore you can't say, I'm going to refuse to do this. I'm going to refuse to serve who I want to serve because I'm from the state of Alabama, Mississippi, whatever. That case was in Birmingham, and so I'm just going to refuse to go by that civil rights. No, you can't do it because you are involved in interstate commerce, and when you're involved in interstate commerce, the federal government has control, because of the Commerce Clause. So that's a very short clause. It's not a long. It's when we talk about the Bill of Rights and we talk about the Fourth Amendment in a minute, the Fifth Amendment, they're not long, very long at all, but they're so very, very important, okay? So anytime you're talking about commerce, you're going to be involved in interstate commerce. It's going to be very hard for you to say that I don't do anything in interstate commerce, because if you use anything, you're going to be using interstate commerce, okay? So that's number 29 there. Let's see, number 32. Let's jump down to 32 here, okay? The Sixth Amendment guarantees a person accused of a crime the right to confront witnesses against him, his accusers, right to an attorney, and right to a speedy and a public trial. Now, first of all, let me say this to you. People ask me all the time, can I come to court and watch a case? Well, you pay for that court, you're taxpayers. You pay the judge's salary, you pay the district attorney, the prosecutor's salary. If it's an appointed case, you're paying the fee for the lawyer, the defense lawyer. If it's an appointed case, the government pays that, the state pays that person. You're paying taxes for the whole thing. The Constitution says you have a right, because public trial means you have a right to come in there. When you look at the Bill of Rights, you got to think about, look at it in historical context. Why did they think that was important? Why were you going to fight a revolution over the right to have a public trial? you got a number of issues in there. We'll talk about some more in a minute, Bill of Rights. Well, because you didn't want the British, you didn't have a situation where the British could come in and try you in front of a military court and sentence you to death, and that's it. You could do it in private. You didn't have a right to have a public trial. If the British didn't want to give you a public trial before the Revolution, you didn't have a right to have a public trial. It was whatever the British told you, that's what it was going to be, okay? So that's the reason you got Sixth Amendment. You got all those Bill of Rights, is because you have a right to public trial, and you have a right, unless it's something, you can't go into juvenile court, it's closed. But any other case, you have a right to walk in that courtroom anytime. You walk in there and you watch any case you want to watch. Because, like with the judge's salary, everybody's in that courtroom except, if it's a domestic case, it won't be paid by the state, the lawyers won't be. But the judges, the bailiffs, everybody else are. You're paying for the utilities for that courtroom. You're paying for everything. So you have a right. You want to watch a case? Absolutely. You go in that courtroom and you watch that case. So let's look at it. Let's talk about Sixth Amendment, that public right to public trial. You have a right to public trial. Have a right to a speedy trial. It's been my experience 48 years, and most time the defendant don't want a speedy trial. If you've got a case where your client, you don't think there's much evidence in the case, you might file a motion for speedy trial, but most time you don't, as a defense lawyer, and I'm just telling you, this is not in a textbook anywhere, but you're going to hear a lot of things in this class, not necessarily in a textbook, because I make my living in the courtroom. Been 48 years doing it. Generally speaking, you're not in a real big hurry to get to court if you're a defendant in a criminal case. Now, if you're in a civil case, you won't get in there and get it done unless you're the insurance company defending the case. You might want to put it off for years, so you won't have to pay the money, okay? But in a criminal case, generally the defense not looking for a speedy trial. You have a right to speedy trial, but generally you get a speedy trial in federal court a lot better than state court. But it's a good example of what you're watching, what's going on in the criminal cases that are going on in our nation right now, and different high-profile cases, how cases get put off. And there's nothing unusual about that. There's nothing you say, well, no, that's what lawyers do. Defense lawyers, not in a big hurry of going to court real quick in criminal cases. So you got all kind of motions you file, and the judge has to hear these motions. If the judge says, I'm not going to hear your motion, then you're going to get if there's ever a conviction, you're going to get a new trial, because the judge should be hearing the motions that the defense lawyer files. The judge don't have to grant the motions, but they got to hear the motions, okay? So that's what that talks about. That's what that talks about on that part of it, okay? So you have guaranteed the person accused of crime the right to confront witnesses against him. Now, let me ask you this. Suppose you're in Russia or China or somewhere. Do they have to bring witnesses against you? Do you have a right to be confronted with witnesses against you? No, you don't. Some politician can say, this is the evidence, okay? In America, if a person accuses you of something, you have a right to confront that witness. If that person accuses you of something, you have a right to put that person on the witness stand that accuses you of whatever they've accused you of. Murder, whatever, rape, robbery, arson, burglary, you name it. If they accuse you of something, you have a right to confront their witnesses against you. In other words, it's right that you have a right to public trial, and the state or the government's got to put that witness on the witness stand and give your lawyer the right to cross-examine that person. Cross-examination is the best sword you have, the best possible item that you have in defense cases is cross-examination. Because witnesses will have their stories, the big part of the story, they'll have it all, this is the way it is. But when you start cross-examining somebody, there's a lot of things they hadn't planned for. And I'm going to tell you this, the loneliest place in the world to be is on the witness stand. You're up there and it's not like an athletic event. It's not where let's say if I got my client on the witness stand and the client's not doing real good, I can't say time out. Time out. We need a break. Don't work that way. The questions are being asked, boom, 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 and the judge says, answer the question, boom. It's going quick. And that's called cross-examination. All right? So when you have that witness that you have the right to confront, your lawyer has the right to cross-examine that person. And I'll tell you this, and I'll tell you this now, and many more times I'll tell you this. I'd rather have a rattlesnake sitting next to me than a timid lawyer. A lawyer that's just not going to say anything, not going to object, is timid in that courtroom. I'd just soon to have me a rattlesnake right next to me. Is that right there? Now, by the way, well, how do you cross-examine somebody? You cross-examine somebody every day. If your boyfriend comes in 2 o'clock in the morning drunk, your girlfriend comes in 2 o'clock or whatever, you're going to cross-examine her, probably. If your child comes back from school and they're in trouble, and you get a note from the teacher, you're going to cross-examine that child. That's what cross-examination is, all right? Now, but when you walk in the courtroom, if you decide, well, I'm just not going to do that, I'm going to be timid and not do it. No, everybody can cross-examine people. Just use your imagination, all right? The witnesses, when they get on that witness stand, they're going to have the basic story lined up. And by the way, if you're going to be a prosecutor, a lot of times the defendant, a lot of times they don't listen to the lawyers. They listen to cheerleaders. They listen to the people around them telling them what they want to hear. And they've told a story to their friends and their family. They say, well, there ain't no way you can lose that case. You tell that you didn't do anything wrong. Yeah, you did. But you've been around cheerleaders and they've told you you're all right. You're not listening to your lawyer. And when you get on the witness stand, that prosecutor starts hitting you with questions. And you did, wait a minute. I didn't go over that with my friends. My friends didn't tell me about that part. It's a lonely place when you're on the witness stand. Like I said, you can't call time out. You're up there and they're hitting you. And my job, I've been practicing law 48 years. I've told you 1,000 times, and I'll tell you more, okay, that I had never had anybody come in my office and say, I just want you to be a good man and be an ethical man, Mr. McDaniel, and if it means I got to go to prison for the next 20 years of my life, so be it. No, they don't say that. They want me to win, okay? All right, now that means if the state puts somebody on the witness stand, or the government puts somebody on the witness stand against them, I have a right to be confronted with those witnesses, my client does, and I have a right to cross-examine them. And the jury has a right to hear that. The jury has a right to hear cross-examination. And we'll talk more about evidence, and when we get into tort actions, we'll talk about how many 8 witnesses or whatever, and how that's like how you cross-examine and how you go into that. But the Sixth Amendment, I hope you're getting the feeling about how important that Sixth Amendment is. That's the reason I put it in here. You have a right to confront witnesses against you, accused, the right to an attorney. All right, now, unfortunately, the right to an attorney, you have a right to have an attorney, but the law says is pretty lax on what that attorney. I mean, there have been cases where this attorney went in the courtroom and maybe was even intoxicated, and they said, well, he did cross-examine. He did do his job. He did cross-examine. There have been some real bad cases, but the courts have held, well, the case was so strong, it didn't matter that the lawyer was incompetent. So you have a right to have a lawyer, but there are, like doctors and lawyers and anything else. I mean, I've told you before, I haven't done no real estate loan closings. I don't draw up corporate. I got lawyers in the firm that do all that stuff. I don't do it. I go to court, make a living there. I've told you that before. You have certain lawyers. Now, if you got let's say you say I got arrested for something, what you didn't, but say somebody else did, your friend, relative, and you say, well, let's go, so-and-so draw their will up. Well, so-and-so that drawed that will up might be the best state lawyer in Alabama, but they might not be a criminal lawyer. They might be the best corporate lawyer. Let's go to lawyer so-and-so, she drew up my corporation papers. She did our estate planning. Well, but she may have never tried a criminal case. By the way, when you go see the lawyer, well, I've done so many criminal cases. Well, how many have you tried? If you've done 5,000 cases and you've pled 5,000 people guilty on plea bargains, you haven't tried any cases. How many juries have you struck? How many cases have you tried? How many have you been lead trial counsel? I'm not talking about second chair. I'm not talking about somebody that did all the research and watch somebody else try the case. When you hire a lawyer to do your case, if it's a courtroom, if that lawyer's going in the courtroom, how many cases have they tried? Now, the law says you have a right to have a lawyer, but it don't say you have a right to have a criminal lawyer. So if you walk in there with a lawyer, they're gonna say, well, you had a lawyer, and if you get convicted and you get life or 20 years or whatever, well, you had a lawyer. You comply with the Sixth Amendment. Okay, that's up to you to find out. Do your research. Lawyers you want the lawyers that are the best at what they do. And I can tell you right now, if somebody comes in the best loan closer in the world, I'm not going to do it. One of my lawyers in the firm will do it, but I won't do it. Be glad to have the loan closed, be glad to have it, but I won't do it. Okay, so that's right. So there's your Sixth Amendment. It is very, very important. I mean, we can talk about any of this stuff. We could talk about the rest of the semester. We could take the Sixth Amendment, and I could lecture on this thing for the rest of the semester, just the Sixth Amendment. Okay. But there's so many cases. When you go to law school, by the way, you go to law school, you'll read on maybe 50, 75 pages on this in your textbook. But at the end of the day, that's it. When you go take the bar exam, that's what you got to know right there. Okay, what is the Sixth Amendment? What does it do? Okay, what's it about? All right. So before we keep going, we've talked about the Bill of Rights, and you put the first 10 amendments there, okay? And if you got your textbook, that would be on page 114 of your textbook there, okay? And it talks about your First Amendment, freedom of religion, press, speech, peaceable assembly. You look at these, why was that important? Because you didn't have those rights. One historian that I know told me, he said that in the Revolutionary War, you had 1/3 of the people wanted to stay loyal to the British. 1/3 didn't want to get involved at all. And just 1/3 of the people wanted to fight that revolution. Think about that. They wanted their rights, but a third of them said, let's stay loyal to Britain. Third says, let's just wait and see who wins. 1/3 fought, okay? Fought for these rights that we're talking about right now. And we're just going to, you're going to make good on your test because I'm going to make sure, you know you are. But I want you to kind of feel this feel this. I mean, why is this stuff so important? Because you didn't have these rights. And once the government takes rights away from you, once they take them, once a case is decided and those rights are gone, it's hard to get them back. Okay? And they will take them. Okay? And that's where you had the only thing standing between you and the government, if it's a criminal case, is a defense lawyer. You got a jury here, you got a prosecutor, you got a jury, you got the judge, and you got a criminal defense lawyer. And that stands between you and the most powerful government in the world, the United States of America. Or if it's a state case, state of Alabama. When I'm in court and I'm representing somebody that says United States of America versus my client, pretty powerful. And I get up in front of the jury and I say, it says United States of America. You know who that is? That's me, you, my client. It's not, the government says the United States of America. Well, it's not just that prosecutor over there. It's you 12 people. It's my client. It's me. It's not just what they say. It's just not what the government, and I always avoid ours. Do any of you believe just because a prosecutor says it, and they say, I'm just, United States of America, they'll stand, we represent the government. Well, just because they say it, does that make it true? Or will you listen to me too? Will you listen to my witnesses just like you would? And that's in the jury selection, you have to ask those kind of questions. But the Bill of Rights, that's what we're talking about here. Read them sometime and see, well, that's what's important. And they do this. I like this right here. You talk about finds that the right, Second Amendment, right of the need of the well-regulated militia for security of the government cannot infringe on citizens' right to bear arms. Third Amendment provides the government cannot house soldiers in private residences during peacetime. Wonder why they put that in. You don't have to hear that. Wonder why they put that in there. Because before the Revolution, if the British want to come in, you've been putting up your crop. You had, you worked all summer and spring and summer and fall. You put up your crop. You're ready for winter. And here comes some British soldiers in and say, we're gonna spend the winter with you. We're gonna eat your food. So that's the Third Amendment. You don't have to quarter soldiers. The government can't put soldiers in your house and say, they can have whatever they want because they're the British government or whatever. People, you had never, I bet most of you listeners had never read the Third Amendment. It's not really important to us now, but it was important then, wasn't it? Important enough to fight for some people to fight the most powerful army and navy in the entire world when we fought that revolution was the British. They were the most powerful army and navy in the entire world. And we, as a little group of people, fought them because we fight for these rights. Bill of Rights here, okay? All right, so let's keep going here, and we'll keep doing our lecture now, get back in that. All right, let's see here, number 33, due process provisions appear in the 5th and 14th Amendments. All right, the 5th Amendment and 14th Amendment, that applies for due process, all right? What is due process? Due process is what we've already talked about in a criminal case, the arrest, felony examination, preliminary hearing. We'll do this more when we talk about criminal law. You don't have to know this right now, but by the way, I'll go through all this in present anyway. The right to a grand jury, being indicted by the grand jury, the right to an arraignment, and the right to a jury trial, okay? That is due process. If you work for the government of the city and somebody fires you, you have a right to due process. You have a right to a hearing, okay? Before they can't just come out and fire you out of the blue. If you work for the government or any kind of government organization, you have a right to due process, okay? That's what that means. In a civil case, complaint, answer, all this discovery, that is due process. The government just can't come in and say, this is what's going to happen. You watch Russian cases, watch what goes on in Russia. You've seen a lot of that lately. You don't have any due process. 99% of the people get convicted? If the politician, if the top person says convict the person, it'd be like you being tried by the congressman or the senator or the county commissioner or something. You don't have a right to have a jury, okay? So we do in America have a right to due process. That's what we talked about a while ago. You have a right for a lawyer to cross-examine somebody, be confronted with witnesses against you. You have a right to due process, the right to a jury trial. You have that right because the 5th and 14th, and the 14th Amendment also says it provides for equal protection law. It says the 14th Amendment been after the Civil War because it said no state shall. They wanted to make sure that the due process clause applied to all the states. And that's what the 14th Amendment did, okay? You'd have a civil war to get that to where it said, if you read the 14th, it says no state shall, okay? So that made the due process, the 5th Amendment, apply due process clause to all states and to provide citizens with equal protection of the law. You cannot treat people unequal. People have equal rights. And if you look at today, you say, well, really? I won't go into that. But think about that, the equal protection clause. If you look at how many people are incarcerated, how many by race, gender, and the like, you just look at the figures. All right. We do by the Constitution have a right to equal protection of the laws, but do we? Okay? But that's the reason I want you people to listen to this thing. If you're going to be lawyers, then do it. And I'll talk about this some more, but you know, if you're going to do it, you're going to be a trial lawyer, be a fighter, okay? You got these rights, and you want to fight to preserve them. So due process is the Fifth and 14th Amendment. Let's get a few test questions before we go further here. And we just kind of, so you can see how this is going. Let's see here. Let me pull some of these out here. Again, these are the exact questions that'll be on your test. All right, this is the question. Constitutional clause that mandates the enforcement of judgments made in other states. A, full faith and credit. We don't have to go further than that, do we? The answer to that's going to be A, okay? Let's see here. Let's look at my numbers here. Okay, next question. Constitutional clause requiring that each state treat all citizens of the other state as they would their own citizens. A, full faith and credit. B, necessary and proper. C, national treatment. D, privilege and immunities. Answer D. Okay, D. All right, let's get another one here. Let's get us another one here. I hope you see how that, I want you, when I read these questions to you, I just want you to see how your test is going to follow this outline here. You know, if I say something, and then from this outline, it's going to probably be on the test, okay? But not when I start saying get off in other, like the preaching part. I don't mean sometimes I get to talk about other cases and things, but try to give you an example of things. But the part you'd be on the test would be what you see in this outline here, okay? So let's see here. The basis for the majority of federal laws regulating business activity is A, import-export clause, B, due process clause, C, commerce clause. What's the answer? It's going to be C. I don't even have to read D. It's going to be commerce clause, okay? Next, the privilege against self-incrimination found in the Fifth Amendment. Well, we hadn't talked about that yet, but I'll go ahead and read it to you. We're going to talk about it in a minute. The privilege against self-incrimination found in the Fifth Amendment applies to A, individuals. Okay, it don't apply to corporations, partnerships, limited liability partnerships. All right, let's see here. Okay, due process provisions appear in 2 amendments to the Constitution. All right, ready? A, First Amendment, Second Amendment. B, First Amendment, Fifth Amendment. C, First Amendment, 14th Amendment. And D is 5th and 14th Amendments. Answer is D, 5th and 14th Amendments where the due process clause is found. All right? Let's see here. Okay. The United States Constitution clause should be the Commerce Clause grants to Congress the power to regulate business activities with foreign nations among the several states and with the Indian tribes. A, Supremacy Clause. B, Commerce Clause. Answer, Commerce Clause. We don't need to go to C and D, they do it. Okay, that's a lot of most questions in this lecture. For some, I don't go through every one of the questions, but I go through enough to where you can see, okay, if he talks about it, if it's in this outline here, there's going to be a question about it. All right. And by the way, after this lecture right here, this will be all the information for your first test. So these first 3 lectures are going to be your first test. Now there'll be some more lectures before your first test, but your first test is just going to cover these first 3 lectures. Now the reason for that is because I want to give you less material that you have to cover on your first test, because I want everybody to get off to a good start here. And if you don't, then that's fine. We'll make that up. But I'll have your first test is just going to be these first 3 lectures. Okay. Now, like I said, we'll have more lectures before your first test, but they'll be on the second test. So after this lecture, that'll be the information on your first examination. All right, let's look at the next one, okay? Number 34. Miranda versus Arizona applies only if law enforcement intends to use the defendant's statement against him at trial. All right, listen, how many times do you think in my practice do I have people come in here and say, I got arrested and didn't read me my rights? Well, what are your rights? Miranda rights. We talked about that. Miranda, we talked about in the first lecture about Miranda versus Arizona, the precedent. Miranda rights, just that you have, if you're going to use a person's statement against them at trial, you first have to tell that person, not the witness, but the defendant, if the person's a suspect in the case, and you got them in there, and they're a suspect to a murder case, let's say, and you're starting to talk to them, and you want information from them, you got to first tell them their rights. You have a right to remain silent. Anything you say can and will be held against you in a court of law. You have a right to have a lawyer with you. If you cannot afford one will be appointed for you. Do you understand these rights? Yes, I do. With the knowledge of these rights, do you wish to make a statement to us? Oh, yes. Well, let me stop that right there and tell you this. When I was a young lawyer, Mr. Jeff Smith was the best criminal lawyer in town then. It was 1976. I started practicing law. I was 24 years old. And I went to see Mr. Jeff about, being a criminal lawyer. What's it like to be a trial lawyer? And never will forget it. I went in his office and he had behind his desk, he had this big old stuffed big mouth bass. Y'all have seen this with big old mouth bass, mouth wide open. Well, they got him stuffed. Somebody caught him in fishing and they stuffed it. He had it behind him. It had a sign under it. You know what it said? It said if he kept his mouth shut, he'd never been caught. Well, how many times you think in my career have my clients already confessed before I ever get the case? Many, many times. Because like people say, well, if I didn't talk to them, they'd think I was guilty. Well, you were. You told them you did it. It's like when somebody gets pulled over and they got, 10 kilos of heroin in the trunk and they consent to the search. And I say, why did you consent? Well, if I hadn't consented, they'd have thought I had dope. Well, you did have dope, and if you hadn't consented, the search would have been illegal. But anyway, we'll talk about that later on here. All right, but anyway, Miranda, so you have their right to remain silent. Now, what if they don't read your Miranda rights? What if I were to shoot somebody in the office here and the police come in and arrest me and take me to jail? Do they have to read me my rights? No. Now, if they start asking me questions, they got to read me my rights. If they're going to use something I say against me in court, they got to read me my rights. But if the dead body, gun, whatever, hey, you're under arrest, or somebody says you commit a crime, do they have to read your rights? Now, let me ask this. If you're the defense lawyer and you're defending somebody in a criminal case, and you know that they didn't read them the rights, they didn't have to read them the rights because they had other witnesses that saw them do it. But are you going to ask your client on the witness stand, did they read you your rights? No, sir. Well, they didn't have to read you rights. What's the jury going to be thinking? Because the jury, like a lot of y'all listen to this right here, I thought you had to read them the rights. I thought they had to do that. No, they don't have to read your rights to you unless they're going to use your confession, unless they're going to use a statement that you made. But I asked that. I'll ask an investigator, in the case, did you read her rights? No, sir, I didn't read her rights. You didn't read her rights to her? No, sir, I didn't. Prosecutor would say, well, why didn't you read her rights when you come back? Well, because I didn't ask her any questions. But the jury's going to be sitting there thinking, well, they didn't read her rights to her. Anyway, that's not in your textbook. That's not in your law book. That's just things you might want to consider doing if you're a defense lawyer in the courtroom. All right, so Miranda applies. Law enforcement, if they intend to use the statements, you don't have to do it in every case, but if you're going to use a confession. All right, 35. Okay, let's look at the Fourth Amendment real quick here. Fourth Amendment, all right? Fourth Amendment, it protects the citizens from unreasonable searches and seizures, ensures that the government issues warrants only with probable cause. That's what the Fourth Amendment says, all right? It's real simple, Fourth Amendment, that you have a right to be secure in your person, your property, and your papers. You have a right to be secure in those. And the Fourth Amendment says the only way the government can search is if they go before a judge or magistrate and the officer goes under oath and swears under oath to facts which shows probable cause, and then the judge signs a search warrant. In other words, there's an affidavit. Here's the way it works. The officer goes before the judge and has an affidavit saying, this is the information I got on this person. Maybe it's a drug case or whatever, a murder investigation, whatever. This is the information I got. And if it goes to the level of probable cause, it's not beyond a reasonable doubt, but it's probable cause. It probably happened. Not that it did happen, not beyond a reasonable doubt, but the crime probably happened. Then the judge will sign a search warrant. But the investigator, the Fourth Amendment says the investigator has to go before a judge. It's very short. You can read it in 30 seconds, okay? It has to go before the judge, swear under oath to these facts, and then if that goes to the level of probable cause, the judge signs a search warrant and you do the search. Okay? All right. Now, let's look at this. So what's some of the exceptions? Okay? The exceptions, Fourth Amendment warrant requirements include, okay, you say, wait a minute. Now, we're looking at 35, and you just told us the Fourth Amendment said you got to do this. You've got to go before the judge or magistrate. You got to swear under oath. You got to have probable cause. And you this word exception, how can that be? Lawyer, how can that be? Teacher, help me. Because the United States Supreme Court has what they say is carved out a few well delineated exceptions to the Fourth Amendment. Exceptions. Now I just got through going through this big lecture about how important the Bill of Rights are, why you fought a revolution for this right, this Fourth Amendment. And then you have the Supreme Court coming out with exceptions. Well, if the Supreme Court gives an exception, then it's law. It's law. So let's look at a few of the exceptions, okay? Searches into a lawful arrest. So if you're lawfully arrested, they don't have to have a search warrant. They can do a search. Items in plain view. I've had clients passed out with cocaine all over them. Passed out at red lights, cocaine on them. The police officer comes up, traffic's backed up, the client's passed out, cocaine all over them. That's plain view. All right. Did the officer have a right to be there? It has to be the officer has a right to be at that place. And the answer is yes, because your client's sitting at the red light and he's passed out because he's got cocaine or whatever on him. Had one had a needle in his arm, passed out, had Narcan to get him, had OD'd at a red light. Okay. Well, that's plain view. Now, what if an officer thinks somebody's growing marijuana, somebody thinks I'm growing marijuana, and they won't sneak up in my yard, and I got a big old front yard, so they gonna crawl up there and they're gonna look in my window and see if they can see marijuana. They can't do that. They don't have a right to be on my property. They got to get a search warrant. That's not plain. What if there's something in plain view, but they have to come all the way up on my land to see that? Well, it's not in plain view. Okay, and you can say, well, what if they had binoculars? Well, then I'm stupid for having marijuana sitting there in my window. But still, they shouldn't be in my yard. The officer has to be a reason. They have to have a reason to be there, not they just. Well, I think this person got enough. We'll snoop around, look in the windows and see what they got there. Well, no, that's not plain view right there. All right, so let's see. That's an exception. Plain view. Consent. We've talked about that. Once you consent to the search, they don't have to get a search warrant. So if you're poor, if there's somebody knocks on your door, hey, can I come in and search your house? Yeah. All right, come on in. No. Say no. You can't. You got to, well, and now listen, if they say, well, if you don't consent, I'm going to go get a search warrant. And you say, well, you're going to get, yeah, if you don't consent, the investigator says, if you don't consent, I'm going to go get a search warrant. Okay, well, if you're going to get a search warrant, is that consent valid? No. Is that officer the judge? That officer, that's not the judge. So he says, when the officer said, I'm going to go get a search warrant, you don't know if you're going to get a search warrant or not. That lawyer lied. It's misrepresentation to you, okay? Now, if the investigator says, if you don't consent, I'm going to go to the judge and attempt, or I'm going to try to get a search warrant, and you say, then you consent, then that's valid, okay? Because the judge, she didn't say, I'm going to go get the warrant, I'm going to try to go get a warrant. It's a difference, okay? And if you consent then, but once you consent, like I said a while ago, if they pull you over for speeding and the officer says, can I search your trunk? And they don't have any probable cause to believe you've done anything wrong, but in your trunk is a dead body or is dope or whatever's in the trunk, and you consent, then they didn't have to have probable cause. You consented to it. There was they just pulled you. I had a client one time, they said, well, this person is the big John Wayne of dope. The investigator pulled him over because he said he's John's biggest dope dealer in the South. And that's where he pulled him over. We knew he'd have dope. That's where he pulled him over. John Wayne or Tom Cruise or dope, whatever, some movie star they used. We knew he was going to have dope in his car. Well, they pulled him over, and he didn't consent. He didn't consent to anything, but they went in and searched it anyway. All right. Now I said this when I filed a motion to suppress the dope, motion to suppress the evidence. If it's an illegal search and seizure, you file a motion to suppress the evidence. If you think the confession is illegally obtained, you file a motion to suppress the confession. So I filed a motion to suppress the dope, said it's illegal search and seizure, and I asked the officer, did my client, who you say is the biggest dope dealer in the South, okay, was he speeding? Did he violate any misdemeanors? Did he violate any rules of the road in your presence? No. Did he commit any misdemeanors in your presence? No. Did he commit any felonies in your presence? No. Do you have a warrant for his arrest? No. Tell the judge why you just don't, the jury don't decide. This is a legal issue. The judge decides the legal issue. The jury decides facts. The judge is the law, and the jury decides the facts, who's telling the truth. But the judge hears the motions, these legal motions. And he said, because I knew he's going to have dope. I'm the head of the narcotics unit. I knew he's going to have dope. Well, you a prophet? No, I'm not a prophet. But I knew he's had dope. Well, it's not probable cause. The judge threw the case out. Now, your client don't get the dope back. I've had clients ask for it back. But you don't. Like if you get a gun case and you win the case, you know, your murder case, and you get the client off, she don't get the gun back. Anyway, so in that case, there was no probable cause. Saying this person is a criminal or whatever, that's not probable cause. That's not a reason to pull a person over or go in a person's house or anything like that, okay? So that's when we talk about that's another issue in the Fourth Amendment right there. Saying stop and frisk, that I won't go into you go into all these so much, and there's so many cases on this. You have to have a reasonable cause to believe a person's doing something wrong to stop and frisk them, okay? And then you get into the plain field doctrine. That's where they pat you down, and if you feel like there's some kind of something that drugs in there, then you can reach your hand in the pocket and get it. It's called the plain field exception to the Fourth Amendment. By the way, if you're going to be in law enforcement, be careful when you go in that pocket because there could be a needle in there. There could be something that you don't want to, touch. Okay, so be careful when you are, if you're in police officer. Now, talk to the police academy and stuff. When you're doing that search and you go in somebody's pocket, be careful when you're going in there. Okay. Exigent circumstances of probable cause. That's called the automobile exception. That's where you pull somebody over for a DUI. You're going to take them in and take them away from the car. So that would, and if you believe that they have probable cause to believe there's something in the car, you don't have to get a search warrant. You can arrest them. It's called. There's also an inventory exception to the Fourth Amendment. If you arrest somebody and you take them to jail, you can do an inventory of the vehicle to make sure there's nothing in there of value where you could be accused of stealing for the law enforcement. And so you can do an inventory. That's an exception to the Fourth Amendment. And so if you find dope or something like that in the inventory, then that's admissible. That's an exception to the Fourth Amendment, which I just started this, when I started talking about the Fourth Amendment, I was telling you that you got to have, to get a search, you got to have a search warrant to search somebody because that's what the Fourth Amendment says. You have, officer has to go before the judge and swear under oath, and the judge has to sign the search warrant. That's what the Fourth Amendment says. You have a right to be secure in your person, property, and places. Yes, that's what the Fourth Amendment says, but there are exceptions to the Fourth Amendment, okay? Let's see here. Emergency situations, border and airport search, customs agents are authorized to search without probable cause and a warrant. There's also the drug courier profile exception. If you meet the profile of a drug courier and you're going through an airport, train station, bus station, you meet that profile, Justice Department has a profile, then they can stop you and search all of your stuff. You missed the plane, that's okay, they have a right to do that. They don't have to have a search warrant if you meet the drug courier profile, okay? Unfortunately, that profile has a lot of Latinos and African Americans. I'm just saying, okay? So drug courier profile, and you don't have to have a search warrant for that. There's also called a good faith exception to the Fourth Amendment. That's where the officer had a different, like say the wrong address, but they did it in good faith. And they found something to the other address or something, they had it wrong, but they did it in good faith. And well, that's an exception to the Fourth Amendment. I don't have time, this is not about, but I got time. But if we could talk about search and seizures again, we could talk any of these amendments that we could take the whole class, and I mean, there are 100 cases on each of these exceptions here, by the way, okay? And so just, we could talk forever on them, but that's just, if you come out and you say, okay, the Fourth Amendment says this, but there are exceptions, and yes, there are exceptions, and that's, they don't have to have search warrants in those exceptions, okay? Let's see here. There's one other thing I was going to talk about here. Okay, number 30, the privilege against self-incrimination found in the Fifth Amendment applies to individuals. All right. Suppose, let's see here, where did we get that right here? Due process. Privilege 7 applies to family claim. It does not apply to corporations. All right. So let's suppose that I get a subpoena for my private records. All right. My lawyer can object to that on the grounds of the Fifth Amendment that I have a right not to incriminate myself, and these records might incriminate me. So I would file a motion to quash the search warrant and say that I don't have to turn this over because it would violate my Fifth Amendment. What if, this is a test question, I didn't go over a while ago, but it is this test question. What if the subpoena is to ABC Inc., for the corporate records of ABC Inc.? Does ABC Inc. have a Fifth Amendment privilege? Answer, no. The Fifth Amendment applies to individuals. So if the subpoena is to Mark McDaniel, then I can claim the Fifth Amendment and say I don't have to testify because I don't have to send those records because it may tend to incriminate me. Okay, but if it's sent to McDaniel LLC, then they have to go because McDaniel LLC would not be it's a corporation LLC. The government would say they don't have a right to the Fifth Amendment. By the way, the Fifth Amendment now, again, that just says you have a right not to be compelled to be a witness against yourself. That's the reason they have to read your Miranda rights to you because of the Fifth Amendment. So if you're subpoenaed to testify before a grand jury and the U.S. attorney asks you a question, you can take the Fifth Amendment. You don't have to answer it. I have a card that I give my clients when they're subpoenaed to testify for a grand jury. And this card says this. They go before the grand jury. Now, by the way, the grand jury meets in the district attorney's office or in the U.S., if it's a federal case, the U.S. attorney's office. Okay? Now, so the grand jury, let's say, is investigating a criminal case, or government fraud or whatever, okay? And so you get a subpoena to appear before the U.S. district, in the U.S. attorney's office for a grand jury in Birmingham, Alabama, let's say. And you come in my office, and I'm going to give you a card. I can't go in the grand jury room with you because the grand jury decides whether or not to return an indictment. Okay? It's not the jury trial. That's the grand jury. They decide whether or not to indict somebody. Okay? Whether or not there's going to be an indictment. Indictment, then, if you're indicted, the case then goes into U.S. District Court. If it's state court, then the circuit court for the trial. Okay? But so let's suppose you get a grand jury subpoena to appear before grand jury in Birmingham, Alabama. You come to me, I give you a card. It says I respectfully decline to answer that question on the grounds it may tend to incriminate me. I'll tell you to go in that room, in that grand jury, because I can't go in there with you, because the only people be in that grand jury room is the grand juror, the court reporter, and the district attorney, or the U.S. attorney if it's a federal case, district attorney if it's a state case. The defense lawyer cannot go in that grand jury room. So I'm out in the hall, and I've given you this instructions to read this. Read this card. Now, if that U.S. attorney wants your testimony, then they have to come out in the hall and say, look, we're going to go before the federal judge, and I'm going to grant her immunity. And once they grant you immunity, then you have to testify because you don't have your Fifth Amendment rights anymore because they're not going to prosecute you. If you tell the truth, they're saying, you tell us the truth about what happened, and we're not going to prosecute you, so that you don't have a Fifth Amendment anymore. You're not going to be prosecuted, so you can't incriminate yourself. So now you've got to get on. Now you've got to tell your story. All right, and it may be against your boss, it may be whatever, but they're saying, okay, you got to testify now. You read the card, which you should do, because if you start testifying, you start lying, they're going to indict you for perjury. All right? And they probably got other witnesses who've already testified, so they're going to pretty much know if you're lying or not. So you're in there, so read that card. And I tell you that now, they're going to try to get you not to read that card, because the U.S. attorney in there is going to say, so you're going to read that card. You're not going to tell us the truth. You got something to hide? I respectfully decline to answer that question on the grounds they tend to incriminate me. I plead the Fifth Amendment. All right, no matter what they say, they ask you, you read that card out. Now, once you start answering questions, you can't come back then and take the Fifth because you've waived your rights. You can't say, well, I'm going to answer these questions and then I'm going to start taking the Fifth when it starts getting kind of dicey. Nope. You give your name and you take the Fifth. Because once you start answering questions, then the law says you've waived your right to Fifth Amendment, and then they can keep going. All right? Read the card. If you come in my office, you have to read the card. If they want your testimony, they got to come out in the hall and talk to me. And, we then go before the U.S. District Judge, and you get the immunity. The prosecutor says, I'm going to give you immunity. Then you go back and you testify at that point right there. All right. That's got this lecture. Now after this, your first 3 lectures will be your first test. But you'll hear 1 or 2 lectures before that test, which will be on the second test. But I do it this way so that you will have not as much information to cover on your first examination. But again, your test comes from this. And I know everybody, you're going to do good when you take your test. If you have a bad night, we'll work on that too. All right, because you're going to have 3 tests in here, and we'll do good. Everybody do good. But anyway, with that, I hope everybody has a great week. And right now, I'm giving this lecture. It's real hot outside. You may be listening. It's not, but y'all have a good week. Thank you so much.